the United States. So I've dealt with cross-border data transfers, and I'm currently an African Union advisor and member of the task force on the African Union Convention on Cybersecurity and Personal Data Protection. Yeah, so when we think about data protection and privacy frameworks development, there are certain key elements that need to be accounted for. First and foremost is the laws and regulations, right? So what is the guiding impetus for you as an organization to be subject to the law? In this case, we have the Uganda Constitution, we have the Data Protection and Privacy Act of 2019, and we have the Data Privacy Regulations of 2021. Now, beyond that, then you also look at the compliance obligations. So what does the law say of you in order for you to be compliant with the law? And then the third pillar is around policy development. So developing the mechanism in which your organization is going to interact with both the regulations and also the individuals whose data you're processing. And then, of course, there's a setting of company standards and controls. And here you're going to be benchmarking your practices against global best practice. And then fourthly is around data protection, risk management, and controls. So making sure that your full spectrum of data processing and data collection, processing, and storage has certain management standards that can be accountable in terms of your management controls. And then, of course, you have the formulation of your procedures. And then finally, the monitoring and testing and audit of your practices, of your policies, of your systems to make sure that they pass muster. So to begin with, I think it's important, and this is something that the audience, I'm sure, is aware of, but the Uganda Constitution does provide the right to privacy in Article 27, the right to privacy of the home, person, and other property. And particularly number 2, which talks about no person shall be subjected to the interference with privacy or the person's home, correspondence, communication, or property. So that's one impetus, right? So that's one impetus for compliance with data protection and privacy regulations. The other impetus, of course, is Uganda's Data Protection and Privacy Act of 2019 and the Data Protection and Privacy Regulations of 2021. They are intended to support privacy protections which are already guaranteed under the Constitution, as I pointed out, and complement sectoral laws for regulated activities that had previously incorporated data protection provision. Now the scope, and I'm sure some of you might be aware of this, the scope of application, particularly of the Data Protection Act, is that it applies to a person, institution, or public body that is collecting, processing, holding, or using personal data within Uganda, or if in the case you're outside of Uganda, then you are collecting, processing, or holding, or using personal data relating to Ugandan citizens. Now, some key definitions that I'll be making reference to throughout the process, throughout this presentation, and it should be important that we have a similar understanding of it pursuant to the Data Protection Act and regulations. So personal data, so obviously this is information about a person from which the person can be identified and recorded in any form. Otherwise, personal information that is about an identified or identifiable individual. It is so interesting also to note that Uganda, unlike many jurisdictions, has a definition for a data collector, where this is a person or institution that collects personal data. And then, of course, you have a data controller, which is an individual or institution that alone or jointly with others determines the purposes for and the manner in which personal data is or is to be processed. And then you have the data processor, and that's a person other than the employee of the data controller that processes personal data on behalf of the controller. And then, of course, the data subject is an individual from whom or in respect of whom personal information has been requested, collected, collated, processed, or stored. And then data processing is really any operation performed on collected data by automated means or otherwise. Then, of course, the Act does provide for the definition of sensitive data, which is generally sensitive data is in data that is relates to political opinion, financial, which is very interesting, financial information, philosophical views, trade union membership, etc. And that interfaces with personal data to create what you might consider to be private data. So again, it is important to make sure that when you are thinking about your privacy, data protection, and privacy framework, that you consider the elements that I outlined below. So for example, we've just breezed through what the laws and regulations have and what kind of definitions they have, but it's so important to have the compliance expectations. And these compliance expectations are what is derived from the law, but also best practice, because there are certain jurisdictions across the world, whether it is the EU or whether it is the US, because the US has also had a long history with data protection standards, or other jurisdictions like Japan, or even Israel, for example, that have advanced data protection standards and frameworks. It is important to make sure that your compliance obligations are meeting this best practice. So the next set of slides will go into what are those compliance expectations? What are the elements of compliance that you in Uganda need to have to make sure that you are not only compliant with the law, but you're also meeting best practice internationally? So first and foremost, the privacy impact assessment or data protection impact assessment. This is pursuant to global practice. You'll find it in regulations across the world. And it essentially conducts a risk assessment of the data that you have collected and seeks to identify what the data is and who has action upon it, and how can you be able to make sure that it is protected. Number two is around data mapping. And data mapping is really meant to make sure that you are mapping data flows, you are considering cross-border transfers, and you basically have complete records of processing. So these are two elements that are important. And by the way, these elements, as I go through them, are elements that we as Africa Risk Management and Compliance Partners are able to help you comply with. Then there's data discovery and classification. Here you discover and classify data according to the various types of data you have, and then you map personal data pursuant to identities that are there that you have within the data. Number four is a very important one, and that's third-party risk management. And by the way, at Armc, we do this on a regular basis for our clients, and we are able to help them make sure that they're managing third-party risk. Because here, you're expected to assess vendor privacy practices and the impact of vendor-led cross-border transfers. You link vendors to the record of processing, and you develop an access policy to these vendors, right? And these vendors could be these are the third-party risk management entities that you need to be aware of. Then, of course, there's incident management. And here you're expected to develop and operationalize incident response, a plan, and manage the incident life cycle, including data breach notification. You might be aware that not only in jurisdictions in Africa, but across the world, that you're expected to notify the regulator. In this case, it will be the Personal Data Protection Office in Uganda of data breaches. Then number 6 is around data subject privacy rights. When I began the presentation in looking at the regulations, We talked about the Ugandan constitution, it providing for the right to privacy. So in the final analysis, when you are thinking about compliance with the Data Protection and Privacy Acts and the Data Protection and Privacy Regulations, it is important to have the data subject in mind, because ultimately you are meant to be protecting the rights of the data subject, even as cross-border flows enable commerce and other social economic activities. So ultimately, with the data privacy subject rights, you're expected to generate workflows, right? From intake to fulfillment. So what this means is that when you receive a request from a data...
Tony Bosa.
Yeah, I'm just wondering why a new domain, eh? You can use the same domain, fix tests and use the same.
Also, we use the data protection domain, but that's when we already have the certificate.
No, I can even issue another certificate. Eh?
Oh,
so you need a CSR for that, yeah?
I don't know. Did I generate a wild card or?
It was a wild card.
Then the same should work.
Okay, so what I'm going to do is stay on the call. Let me call this guy so that you explain to him. You may give... No, it's pretty. No, that one we had it long ago. Don't worry, it has always been there.
This one will test.
Oh, all right, thank you. So we're talking about data subject privacy rights and how important those data subject privacy rights are to data protection and privacy compliance, because in the final analysis, it all relates to this data subject, this individual, this person whose personal data that you're processing. So in this case, you're expected to generate workflows from intake to fulfillment. And intake essentially means when you receive a data subject privacy request. So this could be request about the information. This could be request to edit the information, or this could be a request to delete the information. So you generate workflows from intake to fulfillment, including discovering, deleting, and updating the data about the data subject. Then consent management is number 7, and consent is usually considered to be the holy grail of compliance with data protection and privacy rights, because it emanates. This is when the data subject gives the agreement and accord that you can be able to process their data. So it's so important to be able to collect and centralize the preferences of data subjects, consent, and provide transparency and choice to users. Transparency means that it is important to make sure that the data subject and indeed the regulator is aware of how you're going to be using the data, to whom the data processing is accountable to. So if you have a data protection officer, it's important to have the information readily available so that data subjects and even the regulator can be able to contact them. And choice is another element that is crucial in consent, because it is important that the data subject has the ability to choose whether or not you can be able to process their data. Number 8 is around contracts and data processing agreements, right? So data collectors, controllers, and processors need to enter into contracts in order to share personal data. This enables the data collector, the data controller, and the data processor to have clarity on the expectations that the law has under them. And generally, because the data controller usually has primary responsibility over the data, then they are the ones then that need to make sure that they have contracts in place when they are working with processors, when they're working with any third-party entity that is handling or coming into contact with their personal data of the individuals they have. Then number 9 is around audit and controls management. So here you have to be able to conduct independent reviews and appraisals of your privacy program. So bringing in a third-party entity like the Africa Risk Management and Compliance Partners, Armc, we're able to do that and help you making sure that the policies and procedures you have in place. Basically, your data protection and privacy framework is up to par with the regulatory framework, meaning compliance, but also with risk management, which means it's the risk appetite that your organization has pursuant to the industry that you're in and the types of data that you process on a regular basis. Number 10 is around business continuity. Here it is crucial to develop a plan to prepare for the unprecedented happenings and find existing risks that might disrupt your business or your organization. We use the term business continuity, but in real sense, it's organizational continuity, the ability to make sure that your uptime is significantly hastened in regards to when you have downtime as a result of a data breach, as a result of a malicious attack on your organization. So we are able to help you with that as well. And that's something that organizations, not just in the business or commercial activities, but any organization really, especially if you're handling sensitive kinds of data, if you're handling data that is on a large scale, that is important to make sure to have a business continuity. And by the way, business continuity isn't just good compliance practice, it is also good organizational practice because it enables you to make sure that your organization's activities continue. Then number 11, and we'll get into number 11 in a bit, and that's policy management. So are you able to map your business practices to meet the standards of internal rules and external regulations? Here, what the expectation is that you as an organization have your internal organizational rules and standards that are mapped pursuant to the external regulations that you have, so that you are able to say the regulation, the Data Protection and Privacy Act and the Data Protection and Privacy Regulations have this expectation of us. So how are we as an organization able to meet them? So you need to have those internal rules, because those internal rules enable you to provide guidance to your teams, to your employees. But they also, by the way, are important when you, for example, suffer a data breach or have an incident, a privacy incident, a data protection and privacy incident that brings in the regulator. When the regulator is looking at your internal rules and they see that you do have those internal rules, then it becomes easier for the regulator to give you a slap on the wrist as opposed to significant enforcement mechanisms. Number 12 is around cross-border management. Remember, I said that the Act applies to data that is about Ugandans, even if you are an entity that is based outside of Uganda, but you might also be in a situation where you transfer the data beyond the borders of Uganda in the case of, for example, subsidiaries or multiple corporate entities or organizational entities. So it's important to be able to manage this cross-border data transfer to make sure that you meet localization rules. So here you might be transferring the data to Kenya, for example, or the Ugandan data might be transferred to Kenya. Well, you know, in Kenya, we do not have the definition of a data collector, whereas in Uganda, you have a data collector. So there are nuances and differences in data protection rules and regulations. And so it's important to make sure that you are able to meet those localization rules. Number 13 is around privacy policy. And here you are able to have an accurate, comprehensive, prominently displayed and completely implemented and accessible data protection and privacy policy. And it's so important because this is a communication piece, right? It enables you to communicate to the data subject. It enables you to communicate with the regulator, especially when you have your privacy policy in a displayed in a website or in a place that is accessible to these data subjects primarily, but also secondarily to the data protection regulator, because then they're able to see what kinds of standards you have in place. And then number 14 is training, training, training. Training cannot be overrated. Training is the key to compliance and risk management, because that's when you enable your employees to understand the implementation of your policy, but also making sure that there are mechanisms to address issues of non-compliance. We do training on a regular basis at Armc, at the Africa Risk Management and Compliance Partners, and we're able to enable you as an organization have proper training standards and making sure that your employees are properly trained. And by the way, the training, can be from a senior level management to lower level employees, because they all play a part in data privacy and protection compliance. So I said that I'll get into policy development. And I think when you begin to think about your privacy policy, and this is a document that can be internal facing with the potential of being external facing, posted on your website or prominently displayed so that people, individuals, data subjects can be able to know. It's important to be able to map your data first and foremost, to be able to enable you to actually start developing your policy. So what personal data do you have? What do you do with the data? Other key questions you need to have in mind in order to address policy development is, what information do you hold constitutes personal data? And in some cases, what constitutes sensitive personal data? Why do you process the data? Where did the personal data come from? With whom do you share the personal data, right? So here you can think about third-party entities or processors. And then how long do you keep the personal data? The data retention period, which might be prescribed by law, or it might be based on internal practice. Now, after you've gone through those questions, then the next phase is around making sure that you understand the lawful basis for the processing of the data, right? So for example, I talked about consent being the holy grail of compliance. You can also be in a position where you are processing the data because of a contract you have with the data subject, and therefore, in order to fulfill that contractual obligation, you need to process the data. You can be processing the data on the basis of a legitimate interest you as an organization have. You might be a government body, or you might be subject to a law that requires you to process the data. For example, the Uganda Bureau of Statistics can be able to process sensitive data as part of its normal operation. So the Uganda Bureau of Statistics can be able to say that they have a legitimate interest as an organization that is mandated by government to be able to process data. So the reasoning can vary, that lawful basis can vary, but you need to be able to identify it. And then of course, the other legitimate interests of processing, are there other legitimate interests of processing that are applicable to you as an organization? So therefore you need to look at, when you are processing the data, do you have particular reasons that are defensible under the law that then can say that you are actually allowed to process this data? And especially, by the way, this applies for sensitive data, which is generally, you are generally not allowed to process sensitive data unless you have consent, for example, or unless you're allowed by law or other reasons. Then what rights do individuals have in relation to each type of processing? Here, it's so important to make sure that the rights of the individuals are clear. So for example, one right can be saying that, hey, as a data subject, you have the right to seek information about your information that we are holding as an organization. And this is the individual, so you can put the data protection officer's email address on there, or phone number, or other means of accessing them, or you can have an online form. So these are the rights that the individuals have. Or you can talk about the choice, or you can talk about the choice that data subjects have, in the sense that they can say that they have the choice not to agree to the processing of their data by third parties. The fourth one is around, is there a legal or contractual obligation for individuals to provide data to you. So this goes back to that earlier lawful basis and legitimate interest point I was making. And then number 5 is around do you make solely automated decisions about people that have a legal or similarly significant effects? Here, what it means is that if the processing of the data that you are doing relies on automated decision making, that's generally not acceptable. And by the way, that's the same story what we have in the EU and in other jurisdictions. So it basically requires you to have a human aspect of decision making, so that decisions are not solely automated. So when you do have those solely automated decisions, it's important to be able to notify the data subject, but also have a mechanism where a human being can be part of that decision making. Now, when you're dealing with a wide range of individuals and you have to communicate your data protection framework through a privacy policy, you need to think about the relationships you have with the various groups of individuals whose data you've collected, and whether they will understand the information that you have given them. If you're dealing with vulnerable individuals, including children, you need to draft a language that is appropriate to the level of understanding of the intended audience, and in some cases offers stronger safeguards of data. And then, of course, if you're dealing with people whose first language is not English, it is good practice to draft privacy information in the language that your intended audience is most likely to understand. So, of course, here you rely on whether you have a national language and an official language to be able to communicate that. So best practice in policy development, you need to be concise, clear, and to the point. You need to have transparency. Here it means that you need to make sure that it's clear to the data subject and whoever is reading your policy that they can be able to trace who is handling their data and in what circumstance is the data being handled and what rights do the data subject have. And of course, it needs to be intelligible, so it needs to be understood. You do not use legal jargon because you're trying to communicate to an audience, a data subject audience, layman's audience. And then it needs to have ease of access. So I've made reference to having a data privacy policy on your website. So that can be an easy way to do that. But in some cases, in the cases of banks, for example, I know that when people are opening their accounts, and especially in the US, I've seen this practice where the bank actually gives you the information when you're opening the bank account for the first time. So they give you the privacy information, and then clear and plain language. And it needs to be clear and plain. So I'll hand it over to my colleague and senior managing partner at the Africa Risk Management and Compliance Partner Saudis to go through these.
Okay, thank you very much, Elias. Before Saudis comes in, Saudis is just going to give us an overview in terms of, okay, all these things, how do we put them together in terms of a framework? I believe this is what the assignment was all about for RMC. How do we build up a framework for the risk, and rather for using the process of enterprise risk management in terms of managing the data protection risks and privacy aspects as well. Over to you, Saudis. Thank you.
Thanks very much indeed, David. I hope you can all hear me. This piece, my contribution to this webinar is going to be primarily focused around the interlink between the data privacy regulations and the data privacy framework and how it fits within the overall enterprise risk management framework of an organization. So I think what's really, really important for us to be able to recognize is that data protection risk, and by the same token, cybersecurity risk and information security risk management are all part of the overall enterprise risk management framework. We shouldn't be looking at this as a risk or that's managed outside of context. So at ARMC, we have a framework that we apply in the development of enterprise risk management frameworks for organizations. And some of the key elements of these are outlined here. And this is what I'd like to very briefly go through. Data protection fits very much within the enterprise risk management framework. Data protection obviously has some much higher standards of regulatory compliance expectation compared to some of the other risks we face, but not dissimilar to prudential risks such as credit and balance sheet risk. So what's really, really important from a data protection perspective, risk management perspective, is that we have leadership and commitment. That leadership and commitment from the top means that you get the support and the resources that are required to be able to manage data within your organization to the prerequisite levels. It's also important that data protection and the protection of data or the management of data of information security risk forms part of your principal risk process. It has to be one of the principal risks that the organization itself, through the board and through the executive management, have agreed that it's important that should be managed at the enterprise level. And as we go through that process, it's important to go through the process of looking at the risk appetite setting for data protection risk exposure. The board needs to sign off on the risk appetite. The executives and those responsible for the management of data protection need to recommend a risk appetite level for the information security risk management and for data protection. And the board needs to sign off on that as well. As we say here, the principal risks themselves are linked, and the risk appetite setting is linked to the key drivers of business strategy and business practice. Risk management is essential to data protection. Risk management is an essential element of data protection. As Elias has been alluding to earlier, we look at the areas of risk identification, the areas of risk assessment, and in the areas of risk response. And risk response primarily focuses on the mitigating controls that we put in place once the data protection risks that our organization faces have been identified. I think a couple of key elements that Elias mentioned that I will also just briefly mention here are around the impact on third parties. Because very often when we are in organizations and we talk about data protection, we very much look at what's going on within our organization. But we have a lot of third-party relationships these days. We give a lot of processing to cloud processors, to cloud application processors. Sometimes we actually have third parties that provide first-line services for us in terms of onboarding of clients and customer service management. So we need to look at what the extension is of our data protection responsibilities are into the third-party space. I very briefly want to just talk about one of the other key elements of the ERM, of the Enterprise Risk Management Framework, which is about the 3 lines of defense. I'm not sure how familiar people are with this, so I'll just spend a minute on it. But it's essential that your risk management framework, of which data protection forms part of, is part of a 3 lines of defense strategy, risk strategy. The first line, of course, is the business. The business are responsible for their for developing their data protection policies, standards, and procedures. It's the customers are their customers, so they have the responsibility for doing that. The second line of defense is an oversight function. So second line of defense function would typically be a compliance function, for example. They're responsible for making sure that we have an overall level of oversight, that we have the standards that we ought to comply with, that the policies are in place, and so on, and that they have oversight that business is doing what it's supposed to do to ensure that risk management and compliance is being maintained. And of course, the third line of defense is typically an independent line of defense that is normally run by the internal audit function that allows us all to be able to have a checks and balances around the extent to which we are fulfilling our obligations to the organization from a risk and controls perspective. I guess the last point that we maintain within our ERM framework when we develop ERM frameworks, including data privacy frameworks, is around the question of the areas of monitoring and testing and governance and reporting. There's a couple of slides that are further on in the presentation that I'll be talking to that will address those points. So as Elias mentioned, the overall framework development, once we've talked about the development of standards, one of the core areas that we need to move on to is to talk about how those policies and those standards gets reflected in procedures. So the key point I'm trying to get across here is that in the development of procedures, which are so essential for our colleagues to be able to manage data in the right way, our customer data and our internal business data in the right way, it's important to be able to look at the policies that we've set out in place based on the regulations, the standards that we've set out internally, as well as external standards. And it may well be that Elias may come to talk about this. I'm not sure if we'll have time. We are under a lot of time pressure. But there are standards that have to be set internally, for example, around what is personal data within our databases, what is sensitive data within our databases, and how we treat each of those data. So, for example, where we store data, what sort of level of security is applied to the data that we store. Those are all standards that need to be applied in detail when you develop your framework. And those standards have to be reflected in your procedures as well to make sure that staff aren't actually inadvertently reducing the level of risk management that you have within the firm. And then, of course, as I mentioned earlier, we do have a risk evaluation process that looks at identification, assessment, and response. And that also has to be reflected in your procedures. And that's particularly relevant in the reflection of mitigating controls or data protection controls, which we don't have a huge amount of time to go into, but we have data protection controls that are highly allied to cybersecurity risk management controls. But as Elias mentioned earlier, this is an area that our organization specializes in, and we can support you with the identification of the appropriate controls for your data protection framework. I'll sum up by saying that procedures, it's essential that they're accurate and up to date. The number of times where we see data protection breaches, which is as a result of the fact that somebody knew that what needed to be done, but the procedures had not reflected that new action or that new control that needed to be put in place. They need to be sufficiently detailed, but without being over detailed, so that people they're not complex and colleagues cannot understand them. And by that, we refer to the fact that they must be clear and accessible in their language. The language you use in your procedures must be accessible by people right across the organization. You cannot just write for the most senior people in your organization with the PhDs and all this sort of stuff. You need to write procedures that everybody can use, even the junior who joins us, as well as a colleague who's been there for an intervening period, but is not a senior management executive. And then, of course, your procedures have to have governance, regular review, regular governance to say yes on an annual basis, on a semi-annual basis. We've been through the procedures. They've been signed off by heads of departments who are responsible for the functions themselves, and that we have some kind of date stamp for that sign off. Okay, Elias, my next slide, please. And then finally, I'm also going to be covering the area of monitoring and testing. I think this area of monitoring and testing is hugely essential to the overall development of the framework. I talk here about the fact that it's the place at which we can do stress testing of our framework. A lot of us have frameworks that are built, that are written down, policies that are built, that are written down, that are on shelves, which when it comes to test how well they work, we find out that because we don't do any monitoring and testing or any audits, we don't even know how well our frameworks and our policies, our procedures are working. So it's essential that we have monitoring and testing to stress test our frameworks. Do they actually work when the reality hits the ground? And then it's also a way of being able to look at the levels of embedment. We often look at data protection in isolation, but why don't we think about what it means about the embedment? It's not just to have a nice data protection framework that everybody can gold-plated, that everybody can talk about. It's the practicalities of how does it work in reality. And I highlight a few areas here that we must focus on. HR, human resources, we have a lot of personal sensitive information within our organization amongst our staff. It's important that we are able to focus on that. And then we also have third-party relationships. We have relationships with other partners. For example, some of us might be working with fintechs who are providing part of the solution to our customer, our end customer experience. Some of us might be in public-private partnership contracts and so on. Let's look widely at the level of embedment. How has our data protection framework been embedded across those? There are best practice expectations around monitoring and testing that also need to be taken into account. And then the monitoring and testing must have a very clearly defined methodology, acceptable methodology, including things, for example, like sample selection. Those things have to be taken into account. So it's a lot of efforts to put in place a monitoring and testing program that will give you the results that you require. Testing itself, actually talking about testing, which is key, it has to be risk-based for us to be effective in doing this. Once we've worked out where the highest risk areas for data protection and data protection risk exposure, then that's the basis on which we want to be able to test. And when we test, it's really, really important that we focus on two things: the design of our controls, so the design effectiveness, and then the operating effectiveness of our controls. If we don't design the control properly, it will give us false outcomes. We might think actually that it's actually telling us that everything is green, when in reality, it's actually just giving us false negatives, if you see what I mean. And then finally, it needs to be independent. It really does need to be independent. I hope that this has given you a bit of a flavor for some of the elements around the risk management and the integration of data protection into the broader risk management framework. I'll hand back to Elias, who will begin the summing up. Thank you.
Thank you. I think at this juncture, I would hand it over to David to give us a brief overview of the work that we're doing in Uganda and why you should work with us.
Oh, thank you very much, Elias and Saudis, for the technical information that you shared with us. I don't know how much time we have. I know there has to be a question and answer session, but at this moment, it's for us now to appreciate the PDPO office for having given the RMC opportunity to share their thoughts within the data protection and privacy community in terms of how they can develop their own frameworks. As indicated earlier, as we will see, RMC is well established. I think this was well put by Angela.
David,
yeah.
just a quick one. If you could maybe hold on for a minute and we find out if there's any questions from the audience, then we'll have the closing remarks at once.
Oh, sure, sure.
Okay. Ladies and gentlemen, if you have any questions, I don't see any in the Q&A, but if you have any questions in the chat, please do put them in there and we'll be able to respond to them. So it could be about today's topic or general questions about the Data Protection and Privacy Act. We have the privilege of having our National Director on this webinar, and she'll be able to also answer and respond to some of your queries if you do have any. Okay, David, over to you as we wait for questions from the audience. David?
Yep, really, I was just summing up on our side as we're expecting the questions from colleagues from the community of data protection and privacy. I think this is an opportunity for us in Uganda, having hosted our international colleagues. If there are any issues or questions or even doubts that we are not sure of within the country, it's an opportunity for us to put through the questions. If they cannot answer now, it's something that they can park and definitely come back to us. So as we put together those questions, I'll just give you a background for the ARMC. Some of the information is already there. We're running what we call the risk management wheel, and the data protection and privacy has come in as well. That's why we sourced one of our experts in that area. But there are other areas, just as Saudi has indicated, in terms of risk management, which we do provide advice based actually on the client's needs. Is something that we tailor. At the moment, some of the services that we provided so far has been around the anti-money laundering and what they call the CFT, counter-terrorist protection financing. It's an area that we have so far dealt with the colleagues, or rather with organizations within the country, especially the financial institutions and some of the regulators. We also get on well with the Financial Intelligence Authority team here. So the specialization is really around risk management, and our focus essentially is on the enterprise risk management using the risk-based approach. I think some time back, we were able to liaise also with the Uganda Bank Association, where we had a webinar around the cyber security and financial crimes management and also cyber security, which we did. Again, we have a relationship with them that we provided that information based on their needs, really. At the moment, we're organizing a training which will be based in Zanzibar. If there are any details required, I'm sure at a certain opportune time, Saudi's, in his closing remarks, is something that will give a brief. It is something that our colleagues here in Uganda can take advantage of, because the theme really is about what we are discussing, not only limited to the framework development, but also fairly wide for the approach. It considers a bigger approach. It takes quite a number of days, I think to be 3 or so days there. I believe in the closing remarks, my colleague Saudis will be able to give more of the detail, or in case there are any questions within, we should be able to answer those questions accordingly.
Thank you very much, David, for your closing remarks. I'd like to invite Elias to just give us his closing remarks in regards to what you presented about in about half a minute, if you may, and then I'll invite Saldis and our National Director to close off today's webinar.
Thank you very much, Angela. Thank you, David. Thank you to the PDPO office. Thank you to NITA. Thank you to Uganda for this opportunity. As I mentioned, we dealt with 2 elements within the data privacy and protection framework. We dealt with policy development and we dealt with compliance expectations. But as you can see, there's a lot more that needs to be done if you're going to have a robust data protection and privacy framework. So we welcome the opportunity to provide additional training and discussion around issues like data protection by design, how you go about your privacy impact assessment, how the standards and controls exist in the world, and which ones you should be paying attention to, and other areas. So thank you very much, and we look forward to other engagements.
Thank you very much, Elias. Saldis, in under a minute, your closing remarks in relation to what you spoke about.
Absolutely. I mean, I think my key message to you is that data protection is very much part of your organization's overall enterprise risk management framework. It shouldn't be looked at as something separate. It should be very much part of that. I think Elias echoes very, very clearly everything that we at Armc can do to support you in that process. We're very open, very welcome. We've got David on hand, on the ground, a very experienced risk manager, many years experience. Many people will probably know David from the banking days. So yes, thank you so much for the opportunity to speak to you. We're really excited about working with the Ugandan colleagues. Thank you so much.
Okay, thank you so much. We have 2 minutes to go. There's a question from Esther. The question is about, are there any specific guidelines on sharing customer data with other subsidiaries abroad? Esther, I assume this is in relation to the Data Protection and Privacy Act 2019. I'll have any of our panelists respond to that, but also our National Director in our closing remarks can respond to that as well. Elias or Saldis, would you like to take on this in under a minute?
Could you just repeat the question, Angela?
Are there any specific guidelines on sharing customer data with other subsidiaries abroad?
So that's a good question. The Act does not go into much detail around subsidiaries abroad per se, but there's a general expectation that the standards you have within your organization in Uganda are similar to the standards that are in the subsidiary, pursuant to the fact that they're processing Ugandan citizen data. Right, so if they're processing Ugandan citizen data, they need to have the same standards that you have in Uganda. And of course, I've gone through the compliance elements, the compliance expectations, and those are the expectations that you can have within your organization.
Thank you so much, Elias, for that. And now, ladies and gentlemen, allow me invite our National Director, Ms. Stella Albertese, to give us a closing remark and also to really share her heart with us. Thank you once again. Stella, you're welcome. The platform is yours. Stella, if you're mute, please unmute.
I've unmuted. I hope everyone can hear me.
Yes,
apologies for the lighting in my office. Sometimes it works well, other times it doesn't. I want to thank the participants for attending this webinar, and of course our partners, ARMC, for the great presentation that they've done. We've communicated over the months that we have been operating that we make use of experts, we make use of organizations that we know are able to impart knowledge to our population, to impart knowledge to organizations that need to comply with the law. I want to thank ARMC for breaking down the Data Protection Act of Uganda and also customizing their presentation to what we expect from the various organizations. At the office, we'll continue to provide these opportunities for learning. And of course, we will also make use of the various partnerships and collaborations, such as the one we have with ARMC, to make sure that all of us are on the same page, to make it easy for you to comply, to provide you tools to be able to comply. I would like to encourage the participants, please visit our website. Whatever tools we are developing to help you with compliance, we provide them on our website, and we are available to respond to any questions. We hope that ARMC will also share this presentation so that we can provide it on our website for members to have a review at a later stage. I want to thank you all for participating. And lastly, a round of applause for Africa Risk Management and Compliance Partners for a great job sharing not only their knowledge, but their expertise in this field. Thank you very much and have a good day.
Thank you very much, Stella, for your closing remarks. Allow me to say a big thank you once again to Africa Risk Management and Compliance Partners. Their addresses are right on your screen, and of course to you, our dear ladies and gentlemen, for attending these sessions every month. We sincerely do hope that you gain value out of them, and that the value that you gain out of these webinars is actually taken back to your organizations, and we would like to see results. And we'd also like to hear from you in terms of testimonials. How have these webinars helped you? What have you done in your organizations out of from the knowledge that you gain out of these webinars that has put data protection and privacy at the forefront of your organization. So we thank you very much, and remember to follow us on Twitter at PDPOUG, and LinkedIn, Personal Data Protection Office, Uganda. Our website is pdpo.go.ug. We'll be sharing the slides in the next coming days. But if you need any more information, or if you need to revisit this presentation, do hop over to our YouTube channel and you'll be able to have a full listen into this. So thank you so much once again. Have a great day and a great weekend, and God bless you. Bye-bye.
Thank you.
Thank you.
Thank
Bye-bye.
you.
Thank you.
Bye.